call the member for Maitland.
Thank you, Mr Temporary Speaker. I rise to speak on the National Redress Scheme for Institutional Child Sexual Abuse, Commonwealth Powers Bill. During a 5-year inquiry into the institutional responses to child sexual abuse, nearly 17,000 people contacted the inquiry who were within the terms of reference. The inquiry heard from nearly 8,000 survivors of child sexual abuse in private sessions. The inquiry also received nearly 1,500 written accounts and have referred over 2,500 matters to the police for further follow-up and investigation. So many people in our communities across this nation have been impacted, have been hurt by child sexual abuse. And there are many, many thousands more who would never have been able to give their evidence at the Royal Commission. In 1997, as a young, idealistic public servant in the Department of Immigration, I was tasked with drafting the Commonwealth Government's submission to the then Western Australia inquiry into the British migrant child scheme that operated in that state. While preparing that response, I researched the issue of institutional child sexual and other abuse in great detail. It was appalling and harrowing and horrifying to hear the stories of child after child who had experienced sexual and other abuse at the hands of those in power in the very institutions that we as society had trusted with their care. Children who cowered in absolute terror in their beds during the middle of the night, knowing that there was no way to escape the perpetrators who would come to abuse them. The fear that those children experienced of feet falling down the hall, of doors opening, of shadows lingering over them. Children whose first experience of an adult was not one of a loving and warm, nurturing parent who supported and cared and nourished them, but rather a cruel pedophile who used and abused them sexually, causing mental, emotional and physical pain and harm to them with lifelong consequences. The anger and hurt that these victims and survivors have carried in their lifetimes is without any boundary. None of us can truly comprehend the terrible toll this abuse has had on them. We see the broken lives, the drug and alcohol addiction, the intergenerational family breakdown, domestic violence and even incarceration that are a legacy for many of a childhood ruined by sexual assault and abuse. I think only these children, now adults themselves, can truly understand what happened to them. And I want to read to the House from Leela and Lisa Michelle, two survivors who are directly quoted in the report, who I think sum this up. We were sad, lonely kids torn away from our family and did no one any harm. We should have been cared for and shown compassion for whatever reason we were unable to stay safe with our family. We had no safety net and would have been terrified to tell anyone. And the second quote, every person from family, from relatives to professionals that I went and asked for help from, not only didn't give me the help, but put me in a worse situation. How can a child be protected if the adults and the professionals choose to ignore the abuse? Mr Temporary Speaker, the sense of betrayal and hurt from just two small quotes from two of those many thousands of children who spoke to the Commission, of the many tens of thousands, most certainly, who were impacted by this abuse, send shivers down our spine. And they must engender in all of us an obligation to do more and to do better. During my investigations in the late 1990s in relation to migrant children institutions, I sought legal opinions as to the guardianship under the Guardianship of Children Act 1946, under which the Minister for Immigration delegated his guardianship of those children in many church and community organisations that took them in the name of caring for them. And I wanted to know, as part of my brief, who was responsible, who their guardian was, if it could be put forward. But I think in time, all of us have come, despite the obstructionist of, former governments of both sides of politics, and the bureaucrats that seek to protect governments and the taxpayer from litigation and costly compensation accounts. I think we've all come to the realisation over time that we are all responsible, that we all owe these children a debt. And I think that is probably one of the best things that has come out of the Royal Commission, and not just this Royal Commission, but the inquiry into the stolen generation and other work that has been done in children who, in many cases, have been institutionalised. In fact, 20 years on, we've seen, or 10 years on after I started working on this, we saw the apology to the stolen generation, and we saw the apology in 2009 to the forgotten Australians and former child migrants. And in fact, in this place, we made our own apology to those children from many institutions here. But I think that one of the things that, and why I talk about this history of looking into this issue for myself personally, I think it's important to see the impact that these stories from these children have on all of us, and that's why we need to be making sure that the policies and procedures that we put in place and the legislation and the redress scheme are all correct and achieve the aims and the recommendations of the inquiry. So I want to pay tribute to the courage of all those victims and survivors in speaking out and seeking justice in the face of such ignorance and willful ignorance over so many years. I want to pay tribute to their families of origin, that is, their partners and children as well, and their other descendants who have fought for this for so long. I pay tribute to Joanne McCarthy and other journalists, but particularly her and the Newcastle Herald, for shining the light into the very darkest corners of our treatment of our most vulnerable children. I see Joanne as our very own Margaret Humphrey, CBE OAM, who in the 1980s and 1990s drew attention and sought so much justice for some 7,000 of the UK's British child migrants who were sent to Australia. I also pay tribute to Leonie Sheedy from Care Leavers Australasian Network, CLAN, who did so much work on this, and of course to Julia Gillard, the former Prime Minister, for recommending the Royal Commission. All of the work of these brave people has led us to this bill, which is intended to allow New South Wales to participate in the scheme proposed by the Commonwealth. Mr Temporary Speaker, I'd like to seek a short extension now, just in anticipation.
Member for Maitland seeks a extension of time. Is the extension agreed to? Aye. All those in favour say aye. You say no. Member for Maitland, you have an extension. Yep.
Thank you, Mr Temporary Speaker. I now turn to the bill before us in more detail. Now, the National Redress Scheme provides three elements of redress: a monetary redress payment, counselling and psychological support, and a direct personal response from the institution if it is sought. The scheme provides for administrative rather than a judicial mechanism for redress, and that is important because a lot of these people, as we've heard before from what I was just reading, in their responses, have been hurt so many times, and so many times the onus of proof has been on them. They have been disbelieved, they have been ignored, and they have been let down for far too long by systems and organisations and institutions which should have helped them. So it is right that whatever scheme is in place has a more less complex way of operation. And the test being the reasonable likelihood that a person is eligible for redress rather than the alternate current civil standards of proof. These are very good things. But I do have issue, and Labor has issue, with the fact that the government hasn't been able to come to the $2,000 in compensation or redress payments that were recommended by the Royal Commission, and have capped these at $150,000. And I note that the Attorney-General spoke about the capacity of organisations to pay, but noting that many of those organisations are government organisations, and these people are taxpayers and have been taxpayers and are actually part of our community. We shouldn't be just deciding compensation on the basis of what the perpetrator or the institution which supported that perpetrator can pay. And I think we also need to look at the enormous saving to those institutions from what might have been achieved through common law verdicts in those cases. And also, I want to make mention of the fact that a person can't apply if they're in jail unless they are exceptional circumstances, or if they're sentenced to imprisonment for 5 years, unless the payment does not bring the scheme into disrepute or affect public confidence. Now, I just think that that is such a strange addition to this bill. And I think if anyone in this place has any understanding of the impact of trauma and sexual abuse on a person, they would understand that most of our jails are filled by people who have suffered some level of sexual abuse at some stage. And this is, something that we understand as a causative issue. So to preclude those who, by the nature of their incarceration, have shown that they are so terribly impacted by what has happened to them, I believe is misguided and unfair. The National Redress Scheme is undoubtedly a good thing, but I think we also need to look at the comparison between this scheme and the New South Wales Victims of Crime Scheme, and the amount of compensation to victims who are not subject to being perpetrated against within an institution. Because to me, it seems that if we have someone who has become a victim of crime, and it shouldn't depend on where that crime happened as to what amount of redress could be made to them, and I think that's a real concern. Also, on a probably procedural note, I would like to understand how the government will build the capacity within the system to provide the counselling that will be needed, because I see, as Shadow Minister for Prevention of Domestic Violence and Sexual Assault, many people coming into my office who tell me that the amount of support and counselling, particularly trauma-informed counselling, that is available to them under the New South Wales Victim Scheme is woefully inadequate, and that they have trouble accessing appropriately trained trauma counsellors. And so this is something I think that the Attorney-General needs to turn his mind to, the practical capacity to deliver what is promised. We don't want this watered down or not delivered because we're going to, not actually think about the consequences of all those people going to seek counselling. And I can tell him now that there are people in my community who can't access those services. And then I want to turn to the present and to the future. And we note that this, and as the member for Bankstown said in her speech, out-of-home care is a huge issue. We have more children in out-of-home care now than we ever have had in this state's history. And for us not to think about this in the context of the Royal Commission, I think would be a mistake, and we need to ensure that we have got appropriate safeguards in place. And of course, I have to then come back to the fact that the sexual assault strategy for this state is over 2 years overdue, and that we are just now in 2018 trying to address and to redress the hurts that have happened to children who've been sexually assaulted and abused in institutions right up to the last century. But we need to pay very close attention to what is happening to children in the 21st century, right here and right now, and what will happen to those children. And for that reason, I urge the Attorney-General to put as much pressure as possible. I know I've been told by both himself and the Minister for Prevention of Domestic Violence and Sexual Assault that the sexual assault strategy is coming, but I'd really like it to be delivered, and it needs to be completed and not just... I think we need to actually look at what the experience is for people who experience sexual assault, and they don't need to have announcements that are made on an ad hoc basis about programs. There needs to be a clear way for them to engage with all the services that will be able to help them in recovering from that, and also those that will help them in seeking justice from their perpetrators. So, Mr Temporary Speaker, I commend the bill to the House. Labor doesn't want to stand in the way of sexual assault and abuse survivors of getting appropriate redress, but I urge the Attorney-General to think about those issues in the implementation of this legislation. Thank you.